Good morning, almost afternoon.
Good morning, Judge. How are you?
I'm well. How are you?
I'm doing well, thanks. It's a pleasure to meet
I'm
you.
just the same to you. I'm waiting for the jail to log in. I just tried to call, no one answered. It seemed like there was a bit of commotion down there when I went to get the files, but
Uh-oh.
um yes, and I know that you met with everyone, but I think all but three of people that you met with were probably three are gonna have to wait till tomorrow because they haven't completed the files.
Ah, you know what three those are?
Let's see. Uh, Bisbee is one for sure. Let's see. Believe Perkins.
Okay.
Maybe there's only two that's missing. I'm not sure. I believe it's only two, maybe. Oh, it might be Meredith as well.
Okay. Cool. Thank you.
No problem.
Looks like a lot of fights last night.
It's busy. It's spring, so I guess everyone's extra active. I don't know. I don't know. I have a large pile of files, so see. I don't know what's going on with the jail. Why they're not logged on yet. Hi, this is Judge Simmons. Just wondering if they're gonna log in anytime soon. Thank you. Bye. Can you hear me in the jail?
Yes, Your Honor. Can you hear us?
Yes, excellent. Okay, on the record, yes.
I was going to say, Mr. Bisbee, or I'm sorry, Mr. Patton is upstairs or up front. Yes. And I'm going to go get Mr. Herrera last.
Okay,
Unless you want to do.
good. You said you're gonna get Mr. Herrera last, and I didn't hear what you said about Bisbee.
No, nothing about Bisbee, Your Honor.
Oh, okay, you'll do Herrera last, okay. Very good. Okay, on the record in the matter of the people of the state of Michigan versus Marcus Elijah Patton. Counsel, can I have your appearance, please?
Good morning, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Marcus Patton, who is appearing from the jail arraignment room on Zoom.
Your Honor, Mr.
Yes.
Patton is the one that I told you he's up talking to Ms. CPS.
Oh, okay, sounds good. We'll call that one at another time. On the record in the matter of the people of the state of Michigan versus Aaron Arnold, counsel appearance.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Miss Erin Arnold, who is appearing from the Lansing Jail arraignment room on Zoom.
Okay, you are Aaron Arnold?
Yes, ma'am.
Okay, Ms. Arnold, today's the date and time scheduled for an arraignment. I have here a misdemeanor complaint, and the allegations are that on or about April 11, 2025, at the area at 900 Smith Ave, that's in Lansing, Michigan, Ingham County, that you did allegedly make an assault or assault and battery upon a person by the name of Sandy Ann White, and that this is contrary to Michigan Compiled Law 750.811. Count one is a misdemeanor, and the maximum penalty is 93 days and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge read there and the maximum penalty that's attached to that charge?
Yes.
Okay, you have the right to be represented by an attorney. Someone from the Office of the Public Defender is here today to represent you solely for the purpose of your arraignment. But you have the right to be represented by counsel at all of your court appearances, and the right to be represented by counsel if you're questioned by law enforcement. And if you can't afford to hire your own attorney, you can make a request for the Public Defender's Office to represent you at the expense of the public. Do you understand your right to counsel?
Yes, ma'am.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. So you can plead guilty, you can plead not guilty, or you can stand mute. But if you stand mute, the matter will continue all the way through to a jury trial. And you have the right to have that jury trial. You have the right to be presumed innocent until proven guilty, and the right to maintain your innocence and require the prosecutor prove each element of the charge of assault and battery beyond a reasonable doubt at your jury trial. You have the right to remain silent at your trial and not have silence be used to prove or imply that you're guilty. Your right to waive your silence and testify at your trial if you like. You have the right to subpoena witnesses that will testify on your behalf or present evidence that you believe show a defense to these charges, and the right to see, hear, or question any other witnesses that the prosecutor calls to testify against you. Do you understand the rights that I just went over with you?
Yes.
Is she requesting the public defense to represent her?
She is, Your Honor.
Okay. I'll note that you are requesting court-appointed counsel and that you are entering a plea of not guilty at this time. Are you currently employed?
Yes, ma'am.
Where?
I have two jobs. So I work with Clean Team and the Michigan Athletic Club.
You said Clean Team?
Mm-hmm.
Okay. That's a yes?
I'm
Is that a
sorry.
yes? I said,
Yes,
is that a
ma'am.
yes? Thank you.
Yes,
Michigan
ma'am.
Athletic, very good. Okay, what's your home address?
319 Fenton Street.
And your phone number?
517-490-4476.
You're currently scheduled for a pretrial conference before me, Judge Kristen Simmons. It's going to be April 28th at 8:30. You do have the option of appearing via Zoom. Did you receive a notice to appear?
Yes, ma'am.
Okay. Are you currently on probation or on parole?
No, ma'am.
Do you have any other court dates pending at this time for any other matters?
Ma'am.
Counsel, you can address bond.
Thank you, Your Honor. As Ms. Arnold has indicated, she is employed. She's lived in the Ingham County area for her whole life. She reported to me that she has no prior criminal history, which means she does not have a record of non-appearance in court. I believe that a PR bond with the appropriate conditions would be sufficient to ensure my client's appearance and to protect public safety. Thank you.
Bond will be set in the amount of 500 personal recognizance with a no contact order in place for the protection of the alleged victim, Sandy Ann White.
Thank you, Your Honor.
No problem. You're not to be within 1,500 feet of wherever Miss White lives, works, or goes to school. Do you understand that?
Yes, ma'am.
You're not to have contact directly or indirectly with Miss White. Do you understand that?
Yes, ma'am.
Okay. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to travel outside of the state unless you get approval from the court in advance. You're not to possess a firearm, weapon, or ammunition. And you need to make sure you report to all of your future court dates. Do you have any questions about your bond conditions?
No, ma'am. Oh.
Any additional matters, counsel?
Nothing further, Your Honor. Thank you.
Thank you. You're all set, ma'am.
Thank you.
You're welcome. Michigan versus Timothy McGovern. Counsel appearance.
Thank you, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Timothy McGovern, who is appearing from the jail arraignment room on Zoom.
Okay, Mr. McGovern, today is the date and the time scheduled for a arraignment. I have a felony complaint here. The allegations are that on or about April 11th, 2025, at the area of Baker Street and North Pennsylvania Ave, that's in the city of Lansing, Ingham County, state of Michigan, that you allegedly in count one committed the act of police officer fleeing third degree under the vehicle code, and that you, being the driver of a motor vehicle to whom was given a visual or audible hand signal, voice, emergency light, or siren by Officer Joseph Traverso, a police officer who was in full uniform and in an officer's vehicle, was identified as an official police vehicle acting in the lawful performance of his duty, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey that direction by attempting to flee or elude the officer in an area where the speed limit was 35 miles per hour or less, and that this is contrary to Michigan Compiled Law 257.602A3. Count one is a felony with the maximum penalty being 5 years and or $1,000 in fines, and the Secretary of State shall suspend your license for 1 year if convicted. Count 2, police officer assaulting, resisting, obstructing, as well as count 3 is police officer assaulting, resisting, obstructing. Both counts allege that on or about April 11, 2025 at the area at or near Baker Street in North Pennsylvania, City of Lansing, Ingham County, and count 3 at the area of 120 West Michigan Ave, Lansing, Michigan, that you did allegedly assault, batter, wound, resist, obstruct, oppose, or endanger in count 2, Officer Traverso, and count 3, detention officer Zachary Johnson, both police officers with the Lansing Police Department, that the defendant knew or had reason to know was performing their duties contrary to Michigan compiled law. Both counts 2 and 3 are felonies with the maximum penalty being 2 years and or $2,000. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement, or if the violation was arising from the same transaction. There is an habitual offender third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that order about January 24th, 2024. He was convicted of the offense of carrying a concealed weapon in violation of MCL 750.227 in the 30th Circuit Court for Ingham County, State of Michigan. In that order about November 8, 2021, he was convicted of the offense of carrying a concealed weapon in violation of the law in the 30th Circuit Court, Ingham County, State of Michigan, and therefore the defendant is subject to twice the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges that were read, the penalties attached, and the habitual offender third offense notice, which does enhance your possible penalty?
Yes.
You have the right to counsel. You have the right to be represented at all of your court appearances, and the right to be represented if you're questioned by law enforcement. If you cannot afford to hire an attorney, the public defender's office can screen you for your eligibility to be represented by their office at no expense to you. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, or you can plead not guilty, or you can stand mute. And if you stand mute, this matter will continue all the way to a jury trial. You are being charged with felony. So that means you have the right to have a preliminary examination within 21 days of today's date, unless you waive that timeline or the court finds good cause to go beyond the 21 days. You're currently scheduled for a probable cause conference before Judge Stacia Buchanan, April 25th at 8:15 in the morning. And you can appear via Zoom for your probable cause conference or in person. You have a preliminary examination before Judge Buchanan. That's in person at the court on May 2nd at 9 o'clock in the morning. You should have received a notice to appear for those dates and times. Is that correct, sir?
Yes.
Okay. Again, you have the right to take this matter all the way to a jury trial and maintain your innocence. You're innocent until proven guilty, and you can require that the prosecutor prove your guilt by first proving each element of each of the charges being brought against you beyond a reasonable doubt. You can proceed to trial and maintain your silence and not have that silence be used to prove or imply that you're guilty. You can waive silence at trial and testify if you'd like. You can subpoena evidence or witnesses that will testify as to any defenses you believe you have, and you have the right to see, hear, and question or cross-examine any of the witnesses called by the prosecutor. Do you have any questions about those rights?
No.
You have the right to be considered for pretrial release from custody, but we'll address your bond in just a moment. Is he requesting court-appointed counsel?
He is, Your Honor.
The court will enter a plea of not guilty on your behalf. Do you have address, sir?
707 Beulah Street, Lansing, Michigan, 48910.
Let's see. What is on here? 707 what street?
Beulah, Beulah.
Okay. They have a different address in here. We'll have to get that updated. Are you employed?
Yes.
Where?
I work through Fast Temps at the Lansing Center. I'm a banquet server.
What's your phone number?
517-329-4572.
Are you on probation or on parole?
No,
Do you have any other cases pending at this time?
no,
You can address bond counsel.
Thank you, Your Honor. As we heard from Mr. McGovern, he is employed working as a server for the Lansing Center. He's also a student at LCC. He reported to me that he does have some prior criminal history, albeit they were nonviolent and non-assaultive. He does report that he does not have a history of non-appearance in court, and that he's been in the Ingham County area for roughly 3 years. I believe that a high PR or low cash surety bond would be sufficient to ensure my client's appearance and protect public safety. Thank you.
Thank you. I've reviewed his prior criminal history. I would agree that his convictions are not violent, non-violent in nature, but his prior criminal history does include a number of violent charges, a considerable amount that seemingly all get nollied. There was a domestic violence in 2018. Let's see. Assault with intent to do great bodily harm, less than murder or by strangulation in 2019. Another police officer assault, 2019. Another domestic violence, 2021. Let's see, felonious assault in 2023 and another domestic violence in 2023. So that's a considerable amount of violent allegations, at least. And in this particular case, the allegations are that he either resisted or assaulted officers as they were trying to deploy their duties today, in attempting to at least kick one officer while trying to transport, and then resisting at the detention with the detention officer, and then fleeing and eluding. Personal reconnaissance bond will not be granted because the court believes that there is a risk to the public safety and some flight risk there. I don't have any record of his failure to appear before me because the prosecutor's office has not provided that at this time. Bond will be set in the amount of 5,000, 10% with GPS tether. While out on bond, you need to report to pretrial services within 48 hours of your release. You're not to engage in any assaultive or threatening behavior. You're not to use drugs or alcohol without a prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon or ammunition. And you need to report to all of your court dates. Do you understand those conditions?
Yes.
Do you have any questions for the court at this time?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
Thank you. You're all set.
Mr. Patton is back in the room.
Thank you. Okay, on the record in the matter of the state of Michigan versus Jeffrey Lynn Smith. Counsel, can I have your appearance?
May it please the court, David Capelli, Assistant Public Defender, appearing on behalf of Jeffrey Lynn Smith, who is appearing from the jail arraignment room on Zoom.
This is file number 25-00758. Okay, Mr. Smith, I have a complaint of violation of your conditional release from custody. The allegations are that you were not to have contact directly or indirectly with the alleged victim in this matter, a Jameer Boykin, and that on or about April 12th at 5:05:15, that you violated those conditions by having contact directly or indirectly with the alleged victim. Let's see here. As I read the report, there's also allegations that you were intoxicated and refusing to leave. That also would be a violation of your bond conditions because you're not to use, purchase, or possess alcohol without, or drugs without a valid prescription. And I believe you have a pending court date before me on this matter already. So you have the right to have a contested hearing on this violation. You have the right to be represented by your attorney at the time of your hearing. If you're found to be in violation of your bond can be revoked pending the underlying resolution on the charge that you're proceeding on in this case. Do you understand that?
Yes.
Okay, I'm not sure when your next court date is off the top of my head, but I do know that I just saw you last week and you were provided your next court date. And so we'll have this matter set for a hearing on the bond violation at that time, okay?
Yes.
The court will enter a plea of not guilty at this time, and we will set a hearing. Counsel, you can address bond.
Thank you, Your Honor. Mr. Smith understands the seriousness of this violation, and I would point out to the court that he's indicated to me that this is just his only criminal history, that he doesn't have a record of non-appearance in court, He's been a longtime Ingham County resident. I would ask that bond be reinstated at your discretion.
Okay, so Mr. Smith, I don't know if there's maybe some other way I can help communicate the bond conditions for you so that we can be clear moving forward. You're being charged in this matter with a child abuse, fourth degree. You understand that?
Yes.
And you have a final pre-trial, I believe, pending up in the next upcoming weeks. And I released you out on a bond on this matter. You were released on bond, not necessarily by me, by Magistrate Milmore at the time of your arraignment. And you were given certain bond conditions. And one of those conditions is that you are not to have contact directly or indirectly where the alleged victim, that being your minor grandson, lives. Do you understand that?
Yes.
You're not to be where he works, goes to school, or do any other activities. You're not actually to be within 2,000 feet of wherever he is. Do you understand that?
Yes.
I can attest to the fact that Mr. Smith does not have a history of failure to appear in court, maybe failure to appear in court on time, but he will appear. And so on that, I will continue his bond as it was originally set. I am admonishing you, though, however, if I get another violation that you have been in the area at or where the alleged victim is, I will just revoke your bond and you'll sit in jail pending any hearings, okay?
Yes.
Do you have any questions about your bond?
No.
Okay, any other ways that I can help you understand how to be compliant with your bond conditions?
Right now, I mean, I live with that resident, 1424 Georgetown. He was there visiting. So if he's come by, I have to leave.
Absolutely,
Yes, ma'am.
absolutely. And my records reflect that he's not just living or visiting at the address, that he was placed there by a CPS. So you're not to be there. That's the information I have. I don't care if he stopped by to give his grandmother a hug. You can't be within 2,000 feet of him, so you should take off running when you see him. Do you understand that?
I will.
While this case is pending, so that you avoid any further pickups for violations of your bond conditions. Okay.
Yes.
Any other questions that I can help clarify for you?
No.
Any additional matters for the record?
Nothing further, Your Honor. Thank you.
You're all set.
In a second.
I mean, I can take one more.
This is the people of the state of Michigan versus Timothy Harris. The file number is 25-00614. Appearance, please.
Good afternoon, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Timothy Harris, who is appearing from the jail arraignment room on Zoom.
You're Mr. Timothy Harris. Are you Mr. Timothy Harris?
Yes, ma'am.
Okay, today was the date set for an arraignment on a PA 53, which is a bond violation. I have a police report here that indicates that allegedly on April 11th, 2025, you, at approximately 4:33, you violated the conditions of your bond, which are not to be in contact directly or indirectly with the protected party, or not to be within 2,000 feet of wherever the protected party lives, works, or goes to school. The police report indicates that your GPS tether picked up an exclusion violation for approximately 30 minutes, it looks like, at this date and time. But that would be in violation of your bond conditions. Your bond can be revoked. You could sit in jail pending any hearing or determination on the violation. You also, if found guilty of a bond violation, could be found liable for contempt of court. So bonds are court orders. And so if you violate it, it's punishable by a contempt, which is a maximum 93 days in jail and or $7,500 in fines. Do you understand that?
Yes, ma'am.
Okay. You have the right to have a contested hearing on the violations and the right to have your attorney represent you at this hearing, and the right to have the prosecution prove the violation beyond a reasonable doubt. You already have a public defender on this matter, is that correct?
Yes, ma'am.
Okay, and this matter, I believe, is scheduled before Judge Buchanan. And so that matter, the court will enter a plea of not guilty on your behalf as to the violation. And it'll be set for a hearing on that violation. And you'll get notice of that in the mail. What's your address?
1500 and then West Willow Ave in Lansing, Michigan.
Okay, so the notice will go to that address. Counsel, you can address bond.
Thank you, Your Honor. Mr. Harris understands the seriousness of his bond violation. He reports that he was working at the time that he was in the exclusion zone. He reported to me that he doesn't have any violent or assaultive crimes on his criminal history, and that he doesn't have a record of non-appearance in court, been in Ingham County for his whole life. I would ask that the court reinstate bond at your discretion. Thank you.
Okay, and when your tether started beeping, did they try to contact you at all?
Yes, ma'am.
Did you let them know you were working?
Yes, ma'am. And I was in a closed locked gate for like storage, so I couldn't get out without the. I know I'm not even supposed to say I'm sorry, but yeah, I was just in a
No,
locked gate.
I'm just asking if anybody let you know that, or if you let them know that you were working. I
Yes,
recognize
ma'am.
that your job probably put you around the city. I would have your attorney address your work issues with Judge Buchanan, so that if it needs to be addressed for the exclusion zone purposes, it can be done to avoid you getting picked up on a bond violation. I'm going to continue your bond. You're all set.
Thank you so much.
You're welcome.
This one's.
This is the State of Michigan versus Elijah Williams in 24-01597. Appearance, please.
Thank you, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Elijah Williams, who is appearing from the jail arraignment room on Zoom.
Okay, you are Elijah Williams.
Yes.
Okay, Mr. Williams, I have a misdemeanor complaint that you're going to be arraigned on today, and the allegations of that on or about April 21st, 2024, at the area of 929 East Shiawassee, Apartment 7, that's in the city of Lansing, Ingham County, state of Michigan, that you allegedly committed the act in count 1 of aggravated domestic violence upon Olivia Pena, an individual with whom you had a dating relationship without a weapon, and did inflict serious or aggravated injury upon her, but without intending to commit murder or to inflict great bodily harm less than murder. And that this is contrary to MCL 750.81A2. That's a misdemeanor, and the maximum penalty is 1 year and or $1,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty, sir?
Yes.
Okay, you have the right to be represented by an attorney. You are represented today from the Office of the Public Defender, but you do have the right to have an attorney represent you at all of your future court dates, and the right to be represented by an attorney if questioned by a law enforcement officer. Do you understand that?
Yes.
Okay, if you can't afford to hire an attorney, you can be screened by the public defender's office to have representation at no expense to you. You have the right to remain silent. Anything you say, anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue all the way to a jury trial, and you have the right to hold that jury trial and maintain your innocence. You're innocent until proven guilty, and you can require that the state proves each element of the charges brought against you beyond a reasonable doubt. You can remain silent at that trial and not have that silence be used to prove or imply that you're guilty. You can subpoena witnesses that will testify at your trial on your behalf. You have the right to question or cross-examine in court any of the witnesses called to testify against you. You understand those rights?
Yes.
Is he requesting court-appointed counsel?
He is, Your Honor.
The court will enter a plea of not guilty on your behalf at this time. You are currently scheduled for a pretrial conference. It's going to be before Judge Tony Flores. It's going to be May 6th at 9 o'clock in the morning. You may appear via Zoom or in person for that hearing, okay?
Yes, ma'am.
Did you receive a copy of the notice to appear?
Yes, I did.
Are you currently employed?
Yes.
Where?
At Applebee's in Jackson, Michigan.
Where do you live?
235 Oak Grove Ave, Apartment A. And it's also in Jackson, Michigan.
And your phone number?
517-894-2106.
Are you currently on probation or on parole?
No.
Do you have any other criminal matters pending?
No.
Counsel, you can address bond.
Thank you, Your Honor. We've heard that Mr. Williams is employed working at Applebee's. He reports that he does not have a record of non-appearance in court and is not on probation or parole at this time. I believe that a PR bond would be sufficient to protect public safety, and a PR bond with the appropriate conditions would be sufficient to protect public safety and ensure my client's appearance. Thank you.
A bond is set at 1,000 personal recognizance with GPS tether. While out on bond, you have the following conditions. You need to report to all of your future court dates. You're not to have contact directly or indirectly with Olivia Pena. You understand that?
Yes.
So that includes no third-party contact, and you're not to be within 1,500 feet of wherever she is. Also, while out on bond, you're not to use, purchase, or possess alcohol, marijuana, or illegal controlled substances. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind. And you are not to travel outside the state without prior approval of the court. Do you have any questions about your bond conditions?
I do have one question. My grandmother is in the process of kicking me out of the house at the moment. So I don't know if that would complicate the tether or a mailing address, but
You're responsible not just for the purposes of your tether, but to report and update any changes of your address or contact information immediately as part of your bond conditions in general. So you change your address and you don't know the court that your address has changed, you may get your court date could change, and then that notice would go to the wrong address, and then you'll end up missing court, and now you got a bench warrant because you didn't take care of your adult business and letting the court know. So that's up to you to let the court know if your address changed, okay?
okay.
Do you have any other questions?
No.
Any additional matters for the record?
Nothing further, Your Honor. Thank you.
You're all set. Okay, on the record in the matter of the people of the state of Michigan versus Marcus Elijah Patton. Counsel appearance.
Thank you, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Marcus Patton, who is appearing from the jail arraignment room via Zoom.
Here, Mr. Marcus Patton.
Yes, ma'am, I am.
Okay, let's see here. I have a misdemeanor complaint here. The allegations are that on or about, excuse me, April 12th, 2025, at the area of 2311 East Jolly Road, apartment 12, that's in Lansing, Michigan, Ingham County, that you did make an assault or assault and battery upon a Demartriana Desiree Ellen Eubanks, a resident or former resident of your household, or an individual with whom you had a child in common, or an individual with whom you had a dating relationship, and that this is contrary to Michigan Compile Law 750.812. Count one is a misdemeanor. The maximum penalty is 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. You understand the charge read in the maximum penalty, sir?
And I ask a question, what do you mean place of confinement?
Like a jail or someplace, if the assault happened someplace where you were confined, then
Okay.
you could be subject to enhanced penalty or a consecutive sentence, okay?
Okay.
Okay. Do you have any other questions about the charge and the maximum penalty?
Yes, ma'am. As for my 2-year-old daughter,
No,
I,
no, no, but I don't want to hear about any facts because you have the right to remain
no,
silent.
it's
Anything
not a
that you
fact.
say, no, don't cut me off when I'm talking. You have the right to remain silent. So anything that you say can and will be used against you. You do have an attorney here who's placed his appearance on the record. My question specifically was about, did you have questions about the charge and the maximum penalty? Not
No,
about
ma'am.
your child. Thank you. All right, so you have the right to be represented by counsel, and you are being represented today for the purposes of your arraignment by the Office of the Public Defender. You have the right in this matter to request the Public Defense Office to screen you to be represented at no expense to you, to determine if you have the right to have them represent you if you can't afford counsel on your own. You understand that, right?
Yes, ma'am.
You have the right again to remain silent. Anything that you say and anything that you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will keep going all the way to your trial date. And you have the right to have a jury trial. You are presumed innocent until proven guilty. And you have the right to have the prosecutor prove your guilt by moving forward to a jury trial and having them prove each element of the charge of domestic violence beyond a reasonable doubt. You can maintain your silence at your trial. You can appear at trial and do nothing. It's your right, and the prosecutor can't use that against you. You have the right to subpoena witnesses to trial to testify on your behalf. Your right to see, hear, or question any of the witnesses that they intend to call to testify against you, and the right to present evidence that you believe show a defense to the charge of domestic violence. Do you have any questions about those rights?
No, ma'am.
Okay, are you currently employed?
Yes, ma'am.
Where?
T-Mobile.
And where do you live?
Currently, I live at that address, but if given the
Okay.
chance to leave today, I'll be at a different address.
Okay. What address can you stay at?
I don't know the address offhand. It will be in my phone. My phone is currently left at the other address that I was just taken from. But it will be my brother's home. And it's off of Jolly and Miller, or not Jolly, Waverly and Miller, all the way down by the new which precinct is that? That's right there. That took over the old school.
Okay. Is he requesting court appointed counsel?
He is, Your Honor.
Okay, the court's going to enter a plea of not guilty on your behalf, and note that you are requesting the public defender's office to represent you. I could find your next court date. Okay. It's like you're currently scheduled for a pretrial conference, and it's going to be before Judge Stacia Buchanan, April 28th at 9:30 in the morning. You have the option of appearing via Zoom or in person for your pretrial, okay? Did you get a notice to appear and Zoom instructions for Judge Buchanan?
Yes, I did, ma'am.
Very good. What's your phone number?
517-435-8306.
Are you on probation or on parole?
No, ma'am.
Actually, I don't see any prior criminal history. Okay, I'm based on the charge and his prior criminal history, I am going to give a personal recognizance bond, but counsel, I'm assuming he wants to make some requests regarding his child.
Yes, thank you, Your Honor. We would have no objection to the PR bond. He has indicated that he would like a one-time visit with police to gain some personal belongings from the residence at 2311 East Jolly, as well as to allow third-party contact to arrange child visitation.
Who would be the third party, sir?
There's a range of different people. Can I give a list, or does it have to be one specific person?
Well, I'm just trying to understand who is the person that you mutually trust that would make these arrangements.
I'm sorry, I interrupted you. I apologize. Go ahead. I'm sorry.
No, that's fine. No, it'll be either be whom?
It'll either be like her mother or my older brother Quentin, or like her brother. So one of them will bring her to me.
You want to have ability to have third party contact through a family member for the purposes of arranging childcare, correct?
Yes, please.
I'm going to tell you so that you're advised. And typically, I don't get involved in arranging childcare and stuff. I leave that to the family court, but I do understand that sometimes, or most times, when you're dealing with these kinds of situations, that could have a heavy impact on you and the child or the children while these matters are pending in court. However, allowing third-party contact could become a slippery slope for you. So you need to be mindful, sir, that you're advising whomever it is, because I am going to allow you to have that third-party contact. You need to be mindful that you're advising them for your own protection, that you are not to have any contact about this case with the protected party, okay? And so that the contact is only to arrange childcare. And so if they were to hypothetically take liberties to ask about this case or say something to the alleged victim about this case, that could somehow come back on you in a negative way. It could be a bond violation for you. So they need to be careful to help protect you as well. Do you understand that that's something, it's your responsibility to communicate to your family when you're asking for the third party contact, correct?
Okay.
Bond is set in the amount of 500 personal recognizance. There is a no contact order in place for the protection of Demontriana Eubanks. Third party contact is allowed for the purposes of arranging childcare only. Also, while out on bond, you're not to use, purchase, or possess alcohol, marijuana, or any other illegal substances. You're not to purchase or possess a firearm or other dangerous weapon. You're not to assault, harass, intimidate, beat, molest, wound, or threaten Miss Eubanks in any way. And you're not to be within 2,000 feet of wherever she is.
Can I say something?
You may.
I currently go to LCC. I'm enrolled at LCC and I will be starting school there. She is also enrolled at LCC and starting school there as well. Well, she's been at LCC. As far as if I have to go down to campus to do testing or anything like that, what is it? What should I do in those circumstances?
You're
If
enrolled and
like,
you take in-person classes?
say it again.
Your classes are in person?
No, my classes will be online, but some of the testing is proxy testing, which means they watch you, and then sometimes that's required that you go down to campus to do that testing.
Okay. Well, it's unreasonable to believe that you can't go anywhere and know everywhere she's going to be. If you are going to class, you're not in the same classes, are you?
We're currently taking the same business classes. But like we're not in class together. We're online classing. I'm online classing. She's online classing. I'm literally just asking about if I go down there to do a proxy test and she happens to be there. They give
Okay,
it like
so you believe you may have proxy testing at the same time?
Yes, but not at the same time. Just if she decides to go on a Monday and I'm already going on that Monday, because usually they give you like 3 to 4 days to do that testing. And then you can choose one of those 3 or 4 days to do that. So if I just happen to be there on Tuesday to do my testing and she walks in through the door while I'm in mid testing, do I have to leave at that moment?
That's unreasonable for you to have to leave, and that this is a mess. It's unreasonable for you to have to leave in the middle of your testing, obviously. However, once your testing is done, you're going to need to leave and you're not to have any verbal communication otherwise. You understand that?
Yes, ma'am.
I don't know. I don't know how the proxy testing works over at LCC at this time, and if there's an ability for you to arrange to do yours privately. I don't know. That's for you to figure out. I don't know how you and your I think this is your child's mother, correct? I don't know how you all
Yes.
have worked out classwork and if you all were both taking proxy testing at the same time, or if someone was watching the child while the other one did. So hopefully the likelihood that you all will both be testing at the same time is not a real issue. Okay?
Okay.
If it presents to be an issue, and it would only present to be an issue if you all are do end up testing at the same time, and then obviously some contact is exchanged. That is when it becomes an issue. Otherwise, and I'm not putting you on GPS tether, so it's not like the tether is going to start buzzing because you are taking your test. But you're old enough to be responsible for your actions and your communications, and we shouldn't have to police you taking a test if you're in school. Okay? As to your request to have law enforcement go with you to get some personal items, in theory, I'm going to allow it, but in reality, law enforcement does not have time to go with people for domestic cases to get their things. So you're going to probably have to get a third party to pick up your things, okay?
That may be a little bit difficult at this time, considering the fact that I was picked up without my phone and all my stuff to contact anybody.
I'm allowing it. I've clicked the section on my order that says that law enforcement is allowed to take you one time to get your items. Good luck to you getting law enforcement to take you to get your items, okay?
I understood. I understood that, ma'am. I don't want to feel like I'm trying to argue or anything like that. I just was letting you know that is the current situation that I'm in. That
I recognize you're in an interesting situation, but I also understand that law enforcement's very short staffed. They don't really have the option or to escort everyone who has a domestic violence or a no contact order over to their stuff while they collect their personal things. And so the court can make other arrangements should that need to be an issue. And I'm telling you now on the record that you do have the ability to maybe send a family member to get your phone or other items at this time, okay?
Okay. Yes, ma'am, I'm sorry.
No problem. Any additional matters for the record?
No, ma'am.
Well, that was for the attorney.
Nothing further, Your Honor. Thank you.
No problem. You're all set, sir.
Thank you, ma'am.
Assuming this is Mr. Herrera.
Yes, ma'am.
Okay, I have several files here. Let's see. Okay, this is the people of the state of Michigan versus Fabian Herrera, file number 24-03703. Counsel, can I have your appearance on this?
Thank you, Your Honor. David Capelli, Assistant Public Defender, appearing on behalf of Mr. Fabian Herrera, who is appearing from the jail arraignment room via Zoom.
Mr. Herrera, do you have some documents there that you need to sort through?
Yes, ma'am. I got quite a bit of paperwork. I'm trying to get familiarized with. I just
I
received
got
it
quite
right
a
now.
bit of paperwork for you too, so maybe I can help you organize it as I go through each file, okay?
Yes, ma'am.
Okay, I have here in this complaint, it's a misdemeanor. The allegations are that on or about November 7th, 2024, at the area of 6200 South Pennsylvania Avenue, City of Lansing, Ingham County, also known as the Mire, did, while Mire was open to the public, steal property of the store that was offered for a sale price of less than $200. That this was contrary to MCL 750.356D4 and contrary to MCL 756.356D4. It says misdemeanor 93 days and or $500 and fines or 3 times the value or difference in the price of the property stolen, obtained, or attempted to be obtained, whichever is greater. Do you understand the charge there and the maximum penalty?
Yes.
In that matter, you have the right to proceed to a jury trial, the right to be represented by an attorney. If you cannot afford to hire an attorney, public defender's office can be appointed to represent you at the expense of the public. You have the right, oh, I think I have another retail fraud here. And another one. Okay, let me open up these files first. Helpful. Okay, Mr. Herrera, in file number 24-03718, I have another misdemeanor complaint that alleges that on or about November 16th, 2024 at 6200 South Pennsylvania Avenue, that you did while Mire was open to the public, steal property of the store that was offered for sale of less than $200 or more, of $200 or more, but less than $1,000. and that this was contrary to Michigan Compiled Law 750.356D. That's a misdemeanor. This retail fraud second maximum penalty is 1 year in jail and or $2,000 in fines, or 3 times the value or the difference in the price of the property stolen, obtained, or attempted to be obtained, whichever is greater. File number 24-03429. You're being charged with a retail fraud third degree, alleging that on or about March 3rd, 2024, at 6200 South Pennsylvania Ave, that you did, while Meyer was open to the public, alter, transfer, remove, or replace, conceal, or otherwise misrepresent the price at which the property was offered for sale, with the intent not to pay for the property or to pay less than the price at which the property was offered for sale. The resulting difference in the price being less than $200, contrary to MCL 750.356D4. That's a misdemeanor. Maximum penalty is 93 days and or $500 in fines, or 3 times the value or difference in the price of the property stolen, obtained, or attempted to be stolen or obtained, whichever is greater. 24-02923. You're being charged with another retail fraud third degree, alleging that on or about June 12th, 2024, at the area of 6200 South Pennsylvania, did allegedly, while Meyer was open to the public, steal property of that store that was offered for sale at a price less than $200. That's a misdemeanor. Maximum penalty 93 days and or $500 in fines, or 3 times the value or difference in the price of the property stolen, obtained, or attempted to be stolen or obtained. File number 24-02854. Retail fraud third degree, alleging that on or about July 15th, 2024, while Meyer was open to the public, you did steal property of the store that was offered for sale at a price of less than $200, contrary to MCL 750.23560D4. That's a misdemeanor. Maximum penalty 93 days and or $500 in fines, or 3 times the value or difference in the price of property stolen, obtained, or attempted to be stolen or obtained, whichever is greater. Okay, do you have any questions about any of those charges that were read to you and the maximum penalty on each?
How many charges were there? About 4? 5?
Let me help you again. I have one, two, three, four, 5 retail frauds right there. Let's see what these are.
Okay.
You have any questions about the maximum penalty on any of those? Okay. In each of those files, you have the right again to be represented by an attorney, and you can make a request to have the public defender's office represent you at the expense of the public. You understand that, right?
Yes, Your Honor.
You have the right to proceed to a jury trial and the right to be presumed innocent until proven guilty, the right to require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at trial and not have silence be used against you. You can waive your silence and testify if you'd like. And you also have the right to subpoena witnesses that will testify on your behalf. You have the right to see, hear, or question any witness that the prosecutor calls to testify against you, and present evidence at trial that you believe show a defense to these charges. Do you have any questions about any of those rights?
Oh, ma'am.
Okay. Let's see. Is he requesting public defender to represent him on each of these?
He is, Your Honor.
The court's going to enter a plea of not guilty on each file. Are you currently employed?
No, ma'am, I'm not, Your Honor.
Okay. Where do you reside at this time?
125 Smith Avenue, Lansing, Michigan, 48910.
You have a phone number?
517-619-5383.
Oh, each of these matters will proceed to a next court date of a pretrial. And I believe they'll each be set before Judge Buchanan. They are.
So Your Honor, all of these are gonna be ran at the same time?
They have not yet been set, but they'll likely be set on the same date
Okay.
for a pretrial. Let's see, you have file number 24-00223FY. And this matter was scheduled for a show cause on August 22nd, 2024. It looks like it said you admits to walking away from House of Commons. You were sentenced to 45 days in jail with credit for 26 days. Balance was due by December 27th, 2024. And that was sentence imposed by, it looks like, Judge Buchanan. This was set for show cause because it looks like you failed to either pay off the balance, and it looks like you were supposed to be remanded for the remainder of your time. Since you only had credit for 26 days, you were supposed to do 45 days. So on this matter, you'll be remanded to see Judge Buchanan. Okay, and then file number 24-02222OM. You were supposed to appear before Judge Buchanan for a sentencing on December 3rd, and you failed to appear. Did you forget about your sentencing? Mr. Herrera, did you forget that you were supposed to appear for sentencing?
I've been really thoroughly taking care of my mother and try to provide for her. She's older, and I guess, yes, it might have slipped my mind. Actually, I forgot all about the legal stuff because I was so focused on my mom. She's terminally ill. She don't have much time, so I've been focused on something else.
I'm sorry to hear that about your mother. Unfortunately, you are going to be remanded to see Judge Buchanan on this so that you can be sentenced because you were supposed to be sentenced over 4 months ago and you're not able to remember it on your own. And that's the basis of a personal recognizance bond. As it relates to your other matters that are all pending in new dates, because you are going to be remanded on the sentencing files, I'm going to give you a 10% bond on each of these. She can obviously amend these once you resolve the other matters, but at least you'll accrue time on this while you're remanded if I give you a 10%. If I give you a PR bond, you will not accrue any time, okay?
Yes, Your Honor.
So bond on each of the retail frauds will be set at 210%. While
So
out
I
on
got
bond,
paid. I'm sorry, Your Honor.
I'm sorry?
I have to pay 200 to get on each one.
No, it's 210%, so you would pay $20. However, I normally would have given you a PR bond on retail frauds. However, because you're being held on one of these files because you never appeared for sentencing, then I need to give you a bond that you can accrue time. Otherwise, you're sitting on dead time, okay?
Yes, Your Honor.
And so once you resolve the sentencing matter, your attorney should be making a motion to have your other bonds amended to PR bonds, okay?
Yes, Your Honor.
Do you have any questions?
Just when do I go to court and all that stuff?
You'll get a new court date once Judge Buchanan staff sets the new court date,
Yes, ma'am.
okay? Any other questions?
No, Your Honor.
Okay, your bond conditions while out on bond is that you are not to use, purchase, or possess alcohol, drugs, or illegal substances. You're not to possess a firearm or any other dangerous weapon. You need to report to all of your court dates. You're not to travel outside the state without prior approval of the court. And you're not to be at 6200 South Pennsylvania for any purpose. Do you understand that?
Yes, Your Honor.
Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
You're all set, sir.
Thank you, Your Honor.
Thank you, Your
Thank you.
Honor.
You're all set. Thank you. That's all we have for today.